we shall proceed to Roundtable Discussion 4, the future of international economic law and technologies. Let us welcome the moderator, Ms. María Vásquez Callo-Müller, and the speakers, Professor Fola Adeleke, Professor Shin-Yi Peng, and Professor Markus Wagner.
Okay, so good afternoon, everybody. Thank you very much for joining us in this Roundtable 4 on the future of international economic law and technologies. My name is María del Carmen Vásquez Callo-Müller, alumni. I come from the University of Lucerne, and I am part of the Trade Law 4.0 team. I'm joined here by a very stellar panel. Each of them have a very distinguished academic career, and I would just like to highlight some of their achievements. So next to me, we have Professor Fola Adeleke. He's a visiting associate professor at Wits Law School in South Africa, an Atlantic Senior Fellow on Social and Economic Equity at the London School of Economics. He's the executive director and co-founder of the Global Center on AI Governance. Fola currently serves as a commissioner for the Lancet Commission on AI and HIV, leading the Governance on Accountability work stream. And he has previously served as co-chair of Trust and Regulation, the regulation work stream for the development of South Africa National AI Strategy. He has also served on various advisory teams, including in the development of Nigeria's AI strategy and the African Commission and People's Rights Study on AI and Human Rights in Africa. So then we have perhaps someone that doesn't need an introduction, Professor Shin-Yi Peng. She's a distinguished professor of law and vice president for global affairs at the National Tsinghua University. She's also a member of the indicated list of panelists for resolving WTO disputes, and she has served as vice president of the Society of International Economic Law. Professor Peng is a former commissioner of the National Communications Commission of Taiwan, and she has published widely in the field of international economic law and detailed trade law. And I must say that she has also published this book in 2024 about international economic law in the era of ratification. A wonderful book, I must say. Professor Markus Wagner is last but not least. He is a professor of law at the University of Wollongong in Australia, and he's an international recognized expert on international economic law and governance, peace and security, as well as Australian and US constitutional law. Professor Wagner has been executive vice president of the Society of International Economic Law, and his recent scholarship focuses on various aspects of this field. And he's currently leading a very interesting project on weaponized trade. So as you see from the backgrounds of my esteemed panelists here, we could have a session discussing mostly detailed trade. We could have a session that will discuss AI, or we could have a session that discusses trade and technologies in the era of geopolitical competition. And I am happy to tell you that we will have all of that. So this is a great panel. The way that we will do this is that I will give my panelists 5 minutes each for some opening remarks, where I would like them to set the ground of what will be the discussion that follows, and I would like to invite them to emphasize on the technological developments that have affected international economic law in the past, and how this adaptation has evolved, and whether we are in similar times now in the age of AI, or whether we are indeed facing different situations, and whether you are hopeful or not on the prospect of multilateralism in this context. After that, we will have a discussion for 40 minutes where we will address different areas of different issues that this intersection of international economic law and technologies raises. And after that, we will have 30 minutes Q&A. This is a very generous time for Q&A because I really hope that some of you will have the opportunity to pose questions to the panel. With that, let's start with the opening remarks, please. Fola, you have the floor.
Good afternoon, everyone, and thank you to Maria for moderating this panel, and to the Executive Committee of SIEL for inviting me to be part of this roundtable discussion. Really grateful for that. So if we are to take a historical perspective to this, and looking at it, at least from an African context, we had the first industrial revolution that laid the groundwork for the current inequalities being experienced by countries today, and this has certainly been exacerbated by lack of access to various technologies because it's disrupted, for example, indigenous economic structures and initiated resource plunder. And then you had the second industrial revolution, which essentially formalized and scaled up this extraction through colonization and systemic re-engineering of African economics, for example, to serve European industrial needs. So we essentially had a conscious construction of dependency. And then that led us to the third industrial revolution, which built on these exploitative foundations and deepened economic vulnerabilities through mineral exports that were persistently done through unfavorable trade terms. And this had cumulative effects of underinvestments in human capital, in industrial capacity, and we had a continued reliance on foreign technology and expertise. So that set us up to the fourth industrial revolution when it arrived, and we've experienced similar patterns of external control of key resources. In this particular situation, control of data and digital infrastructure, which has since taken root. And I believe that states are quite aware of this, and we are seeing an increasing pushback against these patterns of what I call data grab. Two scholars, Codry and Mayers, put it more bluntly and call it data colonialism. And they made comparisons to historical colonialism and spoke about, we first start with exploration, which certainly isn't exploring continental lands, but the virtual territories of our datafied lives. And then that leads to expansion and exploitation, where as we continuously generate data as humans in the 21st century, there is this conversion of our data into economic value, and we've been conditioned to continuously generate that data. And then we have the final phase, which is extermination. And in this sense, it speaks to this civilizing gift of civilizing mission of convenience and efficiency, and this civilizing gift of continuous data processing, bringing new forms of surveillance and exploitation. Now, if we accept that there's this kind of data grab, data colonialism taking place, can multilateralism and trade fix this? And in some ways, I think it certainly can. If you look at the African Continental Free Trade Agreement, there are several provisions which I believe we'll speak to later on in this panel that deal with things around cross-border data flows, data localization, exceptions to non-disclosure of source codes, the location of computing facilities. There's a digital trade inclusion chapter in there. And the AFCFTA, at least, has been developed to foster this regulating harmonization and coherence through international standards. And then, of course, we also have technology transfers, which in the context of TRIPS, for example, developed economies like Canada have reported AI technology transfer programs to fulfill their commitments to incentivize local enterprises in LDC. So there are certainly opportunities for multilateralism to play a role in addressing these concerns around data grab. Thank you.
Super. Thank you. So that's a very optimistic outlook. Professor Peng, please.
Hi, good afternoon, everyone. It's a great pleasure to share this panel. The interplay between IEL and the technology is getting more and more complex. And so the question is, how has technology affected IEL? And when we look at the emerging technologies like artificial intelligence, AI, it is just a further stage of technological evolution. Or we are seeing a real revolution. And these questions are important because our legal response depends on how we see the changes, right? If AI is just a further stage of technological evolution, we might be able to address all the legal issues through, say, evolutionary treaty interpretation, and gradually adapting the trade rules without building or rebuilding new rules. But if the pace and the nature of the change is so rapid and so profound, we might need to think about structural changes or innovative approaches to global technology governance. So are we at the turning point that require an entirely fresh legal thinking? It's a big question, and I don't have a straightforward answer, but I do believe that all the issues we have been discussing in the past 2 decades surrounding digital trade, data policy, all the issues will be amplified. And these new technologies are pushing all the challenges further. Let me give a concrete example here. The criteria for likeness. We love likeness exercise, right? So think about like 20 years ago in youth gambling. Well, that's more than 20 years ago. So in youth gambling, one of the core issues was about whether the online gambling is like the conventional casino, like the casinos in Las Vegas. And I was involved in the third-party submission here. I can still remember how exciting it was when we read the written submission from both parties. They borrowed the likeness criteria from the products, as you know, the product characteristics, user, consumer preferences, end uses, and both parties argue for and against the likeness between the digital products and the conventional services. And the responding party, the United States, even advanced extremely interesting argument like how the exciting atmosphere in a casino is quite unlike sitting, in a quiet room with just a computer. So my point is, at that time, the criteria for likeness seems to be workable between the digital products and the conventional services. But 20 years later, today, think of the AI-driven services. How do we apply the likeness criteria in a world that all the services are driven by algorithms and the machine learning? Now the AI robots are competing directly with human professionals. Can we say that AI-powered legal assistance tool is like, small one, but it's like a domestic junior attorney or paralegal? Can we say that? And in our area, under IEL, favorable treatment discrimination can only be determined if like products or like services can be established, right? So in terms of market access, should a robot, AI-empowered robot be treated the same in terms of market access commitments? Mode 1, Mode 4, Mode 3. And in terms of domestic regulation, currently the qualification requirement, the licensing requirement, malpractice, ethical standard, all are built around human accountabilities. So should AI be treated the same? And if so, who should be liable if the robot makes a mistake? The Microsoft, or the engineers, or you and me, the users? And this will open up many, many, many other questions, such as how do we distinguish between the AI that is used as a tool and the AI that is acting as the main service supplier? So I believe this might be a good starting point for us to rethink how do we apply the trade rules in this rapidly changing technological landscape.
All right, thank you. And this is a tough act to follow. That's always been true, as with Shin-Yi, but let me first say thank you to the organizers. And I want to particularly point out a few people who are just making all of this work. So Agatha and Sunny, who are sort of the SIEL and local person, and they're not mentioned often enough because they make these conferences run. Can I also thank the Taiwanese immigration authorities for not putting me in jail for 8 days, unlike what happened 2 years ago when I traveled through the US. Not yet, yes, maybe on the way out. But my remarks are slightly different, right? So I'll take a much broader view, and I'll say something about how we, maybe as a profession or as a discipline, should think about the changes that we're witnessing and how relevant we can be in the future. So the theme of the panel is essential: how have technologies affected international economic law over time? The answers seem pretty clear. They were powerful facilitators. You might recall Mark Levinson's book called The Box. The invention of the shipping container changed trade as we knew it quite substantially. Maybe not the law, but certainly the way we interact and trade. Dramatically lower transport costs, key driver of 20th century globalization, enabled a much deeper economic system built on a shared set of sometimes factual but also legal principles. The premise of my intervention today, however, is that technologies that we now face, the most attention at the moment is artificial intelligence, generally issues related to the digital economy. They're different. They're not merely facilitating, which is the case with the box. They're not merely facilitating the existing order. They have the potential to, and already are, actively fragmenting this order. And Shin-Yi has talked about this. Some people call this the dark time for international law. We certainly see that at the moment. A period of significant stress and crisis. You just need to open up any reasonably decent paper as we speak, and you can see this happening. And for many, technology is the primary engine of this change at the moment, restructuring the global balance of power and in turn a foundational element of international economic law. I'll speak a little bit about AI and technology, but the main point I think is this. We international lawyers need to change or at least adjust our thinking to remain relevant. I don't think we've done this enough to show how we can contribute to the current debate. We have valuable contributions to make, but I don't think we're making them at the moment. And I'm sort of looking back to the public forum, WTO public forum of last year. I'm looking forward to the public forum this year, where you could just see the sidelining of lawyers in almost every way possible. Now, that may be a good thing for those outside the profession. That's fine, but I do think that there is a question of relevance for the profession at the time. So if you look at the root of this shift that we're witnessing, the knowledge economy, values drawn much more from knowledge as input and knowledge production as an output. We see immense wealth. There's also populist backlash, and I think this development will continue to accelerate. At the same time, we see the AI race, and now I'm trying to come back full circle, becoming a defining feature of geopolitics. And that's not just commercial any longer. It's a struggle for global influence that we've seen in other areas a little bit before in IP, but I think much more a struggle for global influence with the main players being the United States and China, and the European Union trying to do something similar at the moment, I would argue. And they're all trying to sort of establish their own models of how to govern AI. And so the old order is a system under strain, deep legalization, proto-legal system in GATT, then a very legalized system in the WTO. We see something similar in World Bank and IMF. Clearly states as the primary actors, and expansive regulation of state action, deep reaches into domestic policy on trade, investment, competition. And that was by and large a Western sort of project, buttressed by, after what Francis Fukuyama calls the end of history, a very powerful US, which is currently withdrawing and leaving large lacunae And so the question is, what are the symptoms of a fractured IEL? We know the multilateral institution is struggling. E-commerce negotiations are basically not going anywhere. We see continuous challenges with respect to cross-border data flows. It's siloed almost everywhere. Maybe that's good, maybe that's bad, but it's something to be addressed. Instead of a unified system that we had, and maybe this is sort of the kumbaya moment of international relations, I usually call it, that at least sort of the people who were born in the 1970s like me grew up with, that's no longer in place. We see different models. The US has a model, the EU has a model, there's a China model, there's a global South, whatever that means. We heard sort of questions around that yesterday, but there are different competing models, and concomitantly, the geopolitical AI race is fueling a return to unilateral industrial policy. We see massive state subsidies well before Trump came into power, under 2.0, for AI capabilities, and the question then is, where does that leave us? It's a crisis about a mismatching of speeds. We as lawyers tend to be very slow. So the question is, how do we catch up? Or maybe we don't have to catch up, but we need to have a discussion about this, I think. There's a demand, I think, for global rules, but at the same time, there's this nationalistic tendency. Then we get to these regulatory expert models that I briefly mentioned, and then we have the turn towards sovereignty that has also been discussed at various stages. So let me just wrap up. The question, I think, is how do we go forward in designing an international economic law that's relevant, that's adaptive enough for the speed of technology, pluralistic enough for a world with many, many voices, and yet robust enough to prevent a full retreat, whether you want to call it anarchy or not, into something that's not desirable. And if that's too much for you, a world in which power trumps law in far too many areas that most players should be comfortable with. That brings me then to my final question. I'll end now. It's not simply to write new rules for AI and beyond. It's to invent a new mode of governance fit for a fragmented, fast-moving, and much more multipolar world than we've seen before. And the question that I'll leave you with is, are we as lawyers agile enough, or should we be agile enough in this new environment?
Thank you very much. I think all those reflections really set us for a great start. I had here a first question that I wanted to pose, but in light of the statement that Markus just made about the negotiations of e-commerce, they are not going anywhere. So I think this question is more rhetorical than anything. But anyway, I would like just to pose it more as a provocation, perhaps to the other two panelists to reflect on. We now have this proposed agreement on e-commerce. So how does it meet our digital realities, if at all? And again, this is just a quick provocation to just reflect quickly on this, and then we can move on to other things.
I do think that there's if you look at the glass half empty, you can say that there are potential missed opportunities there. The one specific clause that are highlighted in the agreement is Article 12 on open government data, for example. This particular clause, it's a best endeavor clause, and the fact that it doesn't have a strong obligation on government certainly a missed opportunity. But I think it's important nevertheless, because it's an acknowledgement that if in the current moment we are in, when we are criticizing the development of AI models for not being representative enough and not developing nuanced algorithms that reflect the realities of different country contexts and all of that, access to government data potentially solves for some of this, because governments all over the world, more often than not, hold the most comprehensive databases that they can then use to develop, AI models that are truly responsive to different contexts. And this is particularly important, recognizing that, there's a public trust deficit when it comes to citizens consenting to governments making their data available to third parties. You have the problem of legacy systems and data silos, right? How do you have, poorly resourced governments, change their infrastructure to make that data available? You've got the issue of data quality. You've got the issue of, resource and expertise constraints, right? Developing data scientists and AI engineers to assist, and then the accountability question. So how do you, address potential misuse of government data? All of this could potentially have been fleshed out in developing standards and a framework for making government data available. But there are other developments outside of this agreement that are important and could serve as a model to be replicated. So for example, Rwanda, a very small country in Africa, is fast becoming a proof of concept country. They've developed a data sharing policy that essentially, prescribes standards to develop interoperable digital public infrastructure and a data sharing platform to have a controlled data exchange for the development of, AI models on the continent. The Global Partnership on AI under the OECD has developed, a lot of comprehensive research studies about this question of access to open government data. So some of those models potentially serve as important benchmarks for other countries to look towards.
Super. That's looking at the glass half full. That's great. If any of you have another question, okay. Perfect. So I think we all read the news these days about what's going on with regards to trade policy in our current era of interesting times with the US. So the next question, basically, it's about tariffs in this context. It's actually about tariffs and platform regulation, and it's directed to Professor Peng. Because Brazil is facing potential tariffs for regulating online platforms because the judiciary in Brazil has actually ruled on platform liability in some countries, in some cases, and I just quote from what President Trump said about this, that those rulings actually are quite a secret and unlawful censorship orders to the US social media platforms. So platform regulation is actually an issue that diverges among countries. We know that some of the trade agreements have addressed this, mostly US agreements, such as the USMCA, replicating Section 301 of the US legal system, right, on platform liability, which establishes very minimal obligations. But other countries or regions, such as the EU, have taken another approach, such as the Digital Services Act, and I know that Taiwan is also considering this issue. So my question to you, Professor Peng, is, does the topic of platform regulation should be addressed in trade agreements?
Yes. In my view, I think more and more digital trade rules or digital economy agreement will increasingly focus on platform regulation. And because when it comes to content moderations, social media is now playing a more and more active role. Some social media is quite active, right? Taking down our contents, the posts, when they consider it's illegal or inappropriate. But at the same time, certain social medias just do nothing, right? Don't deal with even the basics. Don't even take down the fake news or harmful information or like hate speeches. So that's why many of us have been moving away quietly from certain social media. So, and now the problem is getting more and more complicated because AI is now playing a more and more active role in content moderation in social media. is very often is the algorithm that decides what appropriate or inappropriate. Very often is algorithms decide what we can say and we cannot say. So this raises the question that whether the social media or digital platform should be responsible for the user-generated content, especially when its algorithm fail to take down the inappropriate content or worse, actively push certain fake news to more people, hateful message to more people. And as you mentioned that the USMCA, the digital trade chapter, contains some rules, and that's quite echo what the US domestic regulation to limit the liability of social media from user-generated content. But the EU seems to take a slightly different approach, the Digital Service Act, right? The DSA. Impose additional obligations on digital platform and required transparency in content moderation on social media. And here in Taiwan, the government has been struggling about whether to follow the EU's path. I think the main concerns is about the possible regulatory overreach and the impact on innovation. And so, yeah, my view is that yes, the platform regulation will be increasingly focused, but of course, EU, I mean, the DSA is just a EU law, right? And the EU is not yet incorporated this regulatory approach into the digital trade agreements. But the way I see it is that, that the reach of the DSA goes beyond the Europe, because for large platforms, social media, say mega, it must comply with the European regulations if it would like to stay in the digital market in Europe.
So perhaps we will see that incorporated. If that is not an extraterritorial approach of EU regulation, that perhaps we see that incorporated in trade agreements. That's very interesting, thank you. So to Markus, you mentioned that we are living now in very different times, and we know that the digital trade issues that we have been facing so far, and we have been trying to build this rule framework for digital trade, at least at the preferential trade agreement level, right? And we have, of course, the rules of the WTO, but this more developed at the PTA level. But we are seeing all these conflicting regulatory models, this soft law, light regulation of the US, the EU approach on respect regulation. And we also know that we have concerns about digital sovereignty and data sovereignty. So my question to you is, how do you see that the multilateral of PTA rulemaking, how can they still design coherent rules for the age of AI when everybody seems to be pulling in different directions?
How blunt do you want me to be?
I'll
be very blunt. I don't see that the multilateral level has anything to provide at this point that is meaningful. That's the short answer. The slightly longer answer is that if there is we're seeing these clashing models, right? And Shin-Yi has just laid them out a little bit. We see this attempt at exporting governance models, and we've seen this before, right? We've seen this when I was a very, very junior academic. I spoke with at the time, the director of the Max Planck Institute for Intellectual Property Rights, and he explained in great detail to me how the export of intellectual property rights legislation has paved the way for X, Y, and Z in various countries around the world. And I'd never thought about it in those terms, but I think that's exactly the continuation that we're living in right now. And so then you have to ask yourself, everyone talks about the Brussels effect. I would actually, and we know what that roughly is, that other countries sort of follow the rules because the standard is being set, but there's also another standard being set. The Brussels effect, to my mind at least, is oftentimes an active role being played by government in governance terms. There's also an effect by not doing anything. And in the AI space, there's very large influence in Washington, You just need to look at the inauguration in the second row. On the 20th of January, you could see the influence or the impact that certain players have. And I think that is an effect that we'll never call it the Washington effect or the Silicon Valley effect, take it what you will. But I think it's just as important as the Brussels effect. And now marry this with sort of the nationalism of the Trump administration at the moment that we're seeing, that basically says, to come back to today's news about the 50% threat against Brazil, if you don't, number one, take your measures back against Bolsonaro, which is sort of weird. I've lived in Brazil for a while. It's a long-running story. But also, if there might be IPR issues coming up. That's my suspicion. But Trump is using basically the power of supposedly U.S. companies to also export a model, namely a model of sort of now go to constitutional law, a model of free speech that other countries haven't traditionally been willing to accept. That's what I would call the Washington effect, or whatever you want to call it. Right? And so I think I can't see how those can possibly be married in some ways. What I can see is, and not in the way that some economists do this, some kind of commitment by various blocks of countries and groups of countries, and that's sort of a hope, towards rules such as CPTPP and the EU, that amongst ourselves we trade, whether it's services, whether it's goods, on rules that we've agreed on, and we commit to enforcing these rules. I don't see this with the US at the moment. I just don't. But I can see this with respect to other players because they see value in a rules-based system that clearly is not being seen as a value from Washington at this point.
Okay, so the potential of regionalism then. Fola, you mentioned during your opening remarks that the case of Africa, oh no, please, okay. Yeah.
Former VC.
Just try to balance what you say.
Okay,
but just no matter the Brussels effect, Washington's effect, I think maybe we should zoom out for a moment and to have a bigger picture of the data policy, digital policy, AI policies. I think these divergent approaches will be costly and burdensome, definitely for traders or service suppliers, and that would significantly increase the cost. So if these Washington effects or Brussels effects keep going, then the reality we are facing is that the service suppliers will need to, well, meet different levels of legal obligations, meet different legal standards, and that would be particularly problematic for the SMEs. They lack the resource to deal with the, well, unique requirements in multiple jurisdictions, and definitely direct away from the resources for more effective, efficient business management. So to echo or to what you say, I think there's still room for trade negotiators to start with something, I would say, flexible, practical, modest, dynamic, at least to reduce this fragmentation, and at the same time, well, without intervening too much the policy options. So.
I can just very quickly respond. You find me in violent agreement, but that's been true when we were executive VPs of SIEL. But I think that's the place where I think sort of the mature discussion will probably end up. Which probably at this point, just to be clear, excludes the US. Because I don't think they're able to come to a mature discussion, at least at this point. You might come back to it, but I don't see it happening at this point.
This is also related to the term you use, the minimum standards.
Yeah, perhaps very minimum in the future. Okay, let's see. There is something that I really wanted to ask to Fola, because this is really related to what I think is a sidelight of our times is this concept of sovereignty over data and digital. And we know that in the case of Africa, this has been taken really up by explicitly endorsing one of those concepts. So I just wanted to ask you what the African Free Continental Trade Area is trying to spec with this, and how they are trying to get this result from all the frameworks that they have established with the Digital Trade Protocol, with the Protocol on Competition Policy. So where should we be looking at in those agreements to understand how this will work?
Thank you. So that concept of sovereign or AI sovereignty is potentially fairly controversial, and we need to understand what that means, at least from an African perspective. And when African ministers try to articulate what they mean by sovereign AI, they speak about the capacity of African nations to shape the design, the development, the deployment, and governance of AI technologies. And they usually do that through 6 pillars. So, inventing, using, indigenous data sets, African data sets, building, using, establishing continent-wide compute infrastructure, educating, having an AI talent pipeline, having multi-stakeholder governance, owning African data ecosystems, and also influencing the global discourse. And in terms of what the African Union has done to do that in establishing a rules-based regime, the Digital Trade Protocol, in the Article 5 and 6 of the Digital Trade Protocol, establishes rules of origin for determining when enterprises, platforms, and content qualify as African. And then you've got the annex, which has this broad objective of taking into account trade in African digital products and use of African digital platforms. Article 6 specifically provides that state parties shall not impose custom duties on digital products transmitted electronically, provided they originate from another African country and meet the origin requirements in the annex. But you also then have Article 7, and my colleague Francisca can speak better to this because this is an area of specialty. You've got Article 7 as well, which also deals with, I guess, a 2-layered test on rules of origin. African enterprises need to, it requires, there needs to be this concept of African origin traded by African-owned enterprises or an African digital platform. Now, why is this interesting? It's a departure from the current practice where there is an existing WTO moratorium, which essentially says that members are not supposed to impose custom duties on electronic transmissions, where members commit to not impose custom duties, rather, on electronic transmissions. So because of this departure from global practice, the Digital Trade Protocol certainly does something different, right? And in doing something different, it also potentially places African countries that have signed up to the WTO GSI in conflict, right? Because you've got African countries essentially now having, once the moratorium expires, the ability to impose custom duties, right? Then you've also got several articles on the Digital Trade Protocol which deals with digital infrastructure. There's one that prohibits the use or location of computing facilities within a country's territory, but then encourages the use of such computing facilities. And then you've got Article 24, which also deals with exceptions to ban on source code disclosure on the basis of legitimate public interest disclosures. And then you've got, like I mentioned earlier, the trade inclusion clauses in Article 30. So you've got a plethora of, clauses within the Digital Trade Protocol that seems to address these big issues around sovereign AI and trying to place African countries on a better footing when it comes to the development of AI technologies on the continent. And flowing from the Digital Trade Protocol, you also had recently the Africa Summit on AI, where African countries signed up to a statement that essentially listed 6 key areas, I believe, or 7 key areas that is meant to focus on building, AI on the continent responsibly. So, and there's a focus on talent, on data, on compute, on markets, on investments, on governance, and institutional cooperation. So you can see that, at least at an African Union level, they're trying to establish this rules-based regime and, connect that to their broader objective of achieving AI sovereignty.
Thank you very much. That is a very comprehensive approach to data sovereignty for the African Union. And if we stay with the topic of data sovereignty, I recently got aware that the EU has actually, the EU has this concept as well, but it has released this international digital strategy of how it's intended to pursue future agreements. And actually, they don't seem to make they don't seem to think that this is actually a problem for data sovereignty. They are trying to enhance both topics or both issues hand in hand. So my question to Professor Peng is, can digital sovereignty can actually be a driver for cooperation?
I think from the GDPR to DSA to DMA to AIA, there's a clear pace showing that the EU is, position itself as the leader of global data governance. And we often say, and it's also mentioned by Markus and Fola, that we often say that there are 4 big players. The US is market-driven, the EU is rights-based, and China is state-centered. And Maria, you frame this question in a very special way that you are asking, can digital or data sovereignty actually drive further cooperation? I think this is a very interesting angle because whatever we label it, data sovereignty, digital sovereignty, in my view, the term sovereignty in its nature is about setting a boundary, right? Sovereignty, right? Setting a boundary, and to protect something within the boundary and to protect something on what outside the boundary, right? So I think the key question is, how does data sovereignty or digital sovereignty defend against what exactly? And I would say certain governments and certain big tech companies. So both governments and big tech companies. And to do that effectively, cooperation with like-minded countries is essential, right? You need to work together with a like-minded country to defend certain governments or certain big tech companies. So to answer the question, I think yes, the notion can be a driver for international cooperation.
That's interesting because we know that there are certain groups of like-minded countries, and among this group, the US is missing under the current times. So my next question is to Markus. If the US is stepping back from this traditional leadership role that it had, if we may remember, the digital trade agenda was actually initiated to the Clinton administration and by the US. So how does the future of international economic law and rulemaking in digital and AI looks like without the US? Who will be stepping, if someone, to fill this void?
I've sort of given up on doing crystal ball gazing. Because I've given up on crystal ball gazing, right? I don't know. I mean, if maybe someone else in the room does. I don't. I think there's lots of players who want to shape this, but I actually think that governments might not be the ones who do shape this, specifically in this space, because we see, I think more so than before, incredibly powerful players, private actors, driving this process much, much further and much, much more strongly than I think we've seen in other sectors before. I might overstate that case, but I've purposefully sort of come into this conversation today to be a bit more provocative. If we just see at the market capitalization of some of these players, the way they behave, right? You might recall sort of what almost looks benign at this point, how Uber started coming into certain places, replacing taxis, right? And I lived in the US at the time, they just didn't care. I lived in Miami-Dade County. Miami-Dade County has had a very stringent sort of regulation on taxi ride and ride-hailing services. It didn't matter, right? It was steamrolled. Governments didn't matter. And I think that's the sort of missing piece that we need to start to think about is how do we interact or how do we act with respect to very large and powerful players that oftentimes at this point have the backing. If we're talking about the US, there's other players out there. Don't get me wrong, I'm focusing on the US at the moment, but there's Chinese players out there that also have the backing of, I think Europe just, there isn't that player, or there aren't these players that do the same thing. So therefore I'm focusing on the US and China, and I know less about the Chinese market than I know about the US market, so I'll focus on that a little bit. But if you then have the backing to push sort of that market power even further by governments, I think that's where then you also get a pushback. And you start seeing that pushback a little bit. So that might open up the space for alternative players, but as Shin-Yi said, that creates higher costs due to fragmentations, right? So if we see these local champions or regional champions coming up, it's simply economics of scale that don't work in the same way that they otherwise do. So there's a cost to it, a real cost for consumers. There might be benefits. And I might take a slightly different view on what Shin-Yi said before. I think there are benefits from defending or from putting these boundaries in place. If you think that data, not sovereignty, but if you think that privacy, for example, is a real value, then you might impose that cost, and you want local storage of data. Whether that's actually feasible and realistic is a completely different story for me. But if that's the rule you want to set, because you don't trust, and I think this is the place we've gotten to, you don't trust the rules in the other places, then
Localized data?
yes, localized data storage and so forth, which again leads to larger costs. I get that, right? But I'm being told I'm wrong here in a second by Shin-Yi.
I think that relates very much to my next question, because it's about data, actually, and as someone that has been reading all those cross-border data flows agreement and studying this issue for a long time, I have a question. How does cross-border data flows look like in the age of AI? Like, if we are writing a treaty now, do we have to change the way that cross-border data flows provisions are structured to fit AI? Do we need a provision on non-personal data, for instance, machine data?
Markus told me that he would be provocative, and I promised to bring water to the panel to prevent fires from burning down the panel. So you say something about the data localization, and thank you for the question. I think the cross-border data flows, it's of course given being more and more important in the age of AI, right? To be short, the AI tools rely on the large, diverse, real-time data transmissions, and our data here in Taiwan. When we use the AI tool, our data is collected in Taiwan, analyzed and stored on servers, maybe in the United States. Then the data can be used to improve the AI model globally. right? So without the data flows, the AI cannot learn from diverse contexts, of course. And most AI tools are hosted on the cloud infrastructure that can, across different, multiple jurisdictions. So without data flows, it cannot work. And just don't forget about the manufacturing sector. That's equally important for the manufacturing sector, like TSMC here. The smart manufacturing actually still rely on the data transmission among or between foundries. I mean, the chip fabrication facilities to wash machine to adjust production or increase performance, or sometimes catch problems. So without cross-border data flow, it can also be problematic. So we are facing, here we are again, we are facing the same fundamental question about how to promote the movement of data, but at the same time allowed a sufficient policy space to protect, as you mentioned, privacy, security, and other important interests.
Interest of time, this will be my last question because I do have to give enough time for the public to ask questions. And this is a question for Fola because we know that if we stay with this AI team and we are in the AI race, and this requires significant investments, of course, in data centers, but also in skill capacity. And for instance, those investments are being made in different continents. The EU has launched the AI Continent Action Plan, and they have a whole set of investments that will be made to make this happen. But other countries are also investing in computer-led infrastructure. But if we are realistic, most of those countries are advanced economies that have the money to do that. So what does this mean for the rest of the world? How do we prevent this for exacerbating economic inequality in the AI race?
Thank you. And I think this is where the idea of regional cooperation needs to come back to the table, and the necessity for countries with lesser resources to pull together to be able to attract investments. So, for example, the African Union has set up this ambitious goal of raising a $60 billion Africa AI fund, and how they're going to achieve that requires extraordinary cooperation on their part, because there's an increasing acknowledgement by African states, for example, that you can't go the road alone because you simply don't have that competitive advantage. And so African ministers are increasingly talking about the idea of centralizing AI infrastructure on the continent. And if you are going to be centralizing the infrastructure, then regional integration plays a more dominant role. And in terms of regional, integration playing a more dominant role, it not only applies to the attraction of investments, but it also applies to governance as well, right? How do you set up a data governance ecosystem that supports this kind of centralized infrastructure? So for example, when you have different data protection laws that have different requirements in terms of adequacy for the transfer of data, that then becomes operationally difficult. So having a conversation about, cooperation around cross-border cooperation in addressing personal data, may be a need for having a regional data protection body, for example, then comes to the table. Yeah, thank you.
That's very interesting because, again, that leaves us in a hopeful note on the need for cooperation. And with that, I think I would like to open it to the questions from the Q&A. So if somebody has a question, we see a question there, Professor. We have a mic
Can you hear me? Thank you, Lockney from Singapore. Thank you for a very interesting discussion. I have a question for any of the panelists who might want to jump in. And I was curious as to your take on the role of international economic law agreements on two matters. Firstly, countries are having different approaches regarding balancing innovation, investment, as well as regulation. Because there's a fear that if we don't keep up with innovation and attract investment, we might lose out on innovation, but at the same time, we might want to have regulatory space. So do you think there's a role for IEL agreements to deal with this sort of differences in approach? So that's the first part. The second part is there any role for IEL agreements vis-a-vis different approaches or gaps arising from developments from the collection of data by large language model training? Because the LLMs are the key behind a lot of the big AI software searches that we're doing or the programs that we're using. So intellectual property and other sorts of issues are popping up in that space. Do you think IEL agreements have a role in dealing with some of these issues which they might not presently deal with? Thank you.
So I think I would like to collect 3 questions. And yeah, please, there is one question here.
Thank you very much, Gabrielle Marceau. My question is simple. The title of your presentation was Technology in International Economic Law. Don't you think that existing rules and the absence, the gaps in rules, detailed rules, for instance, on competition, on investment, become more and more important because technology means, as it was mentioned, big multinationals. So I was myself thinking, oh, well, we should look at subsidies. And then a colleague expert in technology said subsidies, but these are given by governments. The issue is more what companies do and don't do. The role of government can regulate. So don't you think that the importance of technologies is a big challenge to the gaps that exist that are recognized as so-called Singapore issues? And now we cannot go ahead without dealing with that because you have companies that are bigger than states that could affect international. Thank you.
There is space for one more question, and then we will have a set of answers. And if there are more questions, then we go for more questions. But if, yeah, one more question.
Sang-Jun Kang. Related to Professor Marceau's question, I think I wonder whether there's a growing need for some regional framework to regulate the cross-border data transfer, or the development of the AI, joint development of AI infrastructure or so, because the current multilateral framework is it's almost frozen because of the geopolitical reality. Thank you.
Okay, I think you all can see where you can answer those questions.
Both questions are quite tough. Luckily, you're asking really the core question about the balance between innovation and the regulation, and what can IEL do or have done or can do in this balancing exercise. This is a big question, and I think actually all the questions we have discussed just all bring up this one key question that about the balance between innovation and the regulation. First, I would say, do not forget our most established tool, the necessity test, right? So the question might be, I mean, the necessity test in this AI age can involve very complex judgments, right? To what extent a trade measure can contribute to the public policy objectives such as algorithmic accountability, non-discrimination, no bias, and is there any alternative measures that can achieve the same level of protection. Like, I don't know, the technical standards for AI or trust certificate. Okay. And in this regard, I think there's always a good starting point about transparency. If you agree with me, that algorithmic transparency, like more and more civil society and the regulators are calling for algorithmic transparency, digital platform transparency. If I'm right, the EC now has the power to invest the IT systems, algorithms, and the training data, and require the big data, the big tech companies to provide access to their IT systems. And more and more FTAs contains the trade rules regarding source code and algorithms. For example, the USMCA bans the mandatory transfer of source code and algorithms as a condition for digital trade market access. So a USMCA party seeking access to the algorithms of a foreign digital platform, unless can be justified by the exceptions as a condition for market access, will violate the USMCA digital trade obligations. And this kind of trade rules, returning to your questions, these kind of trade rules have raised concerns about the right to regulate, right? And some scholars believe that the trade rules may make it even more difficult for the regulators to verify legal compliance. But I have a different view that I actually believe that the trade rules regarding algorithms in the digital trade chapters is a very good example for us to reflect on what IEL can do and have done. Because if we look at the exceptions in the digital trade chapters, it specifically say that the regulators and the court can access to the algorithms for the purpose of legal compliance and law enforcement. And don't forget, we always have general exceptions and security exceptions that arguably can, in many cases, can justify our data policy and AI policies. So my view is that let's hope IEL can meaningfully contribute to this balancing exercise. Can I also quickly respond to Gabriel's question? I totally share your viewpoints. I think trade and the competition, I mean, it's about time to bring back, if possible, to bring back the conversation on trade and the competition policy. As Gabriel mentioned, that it was introduced in the WTO talks in Singapore back in 1996, but members make little progress, and the topic was eventually dropped from the negotiation agenda. But it's about time to think about it, because the power of the large big tech companies or large platforms can only be meaningfully addressed or constrained at the international level. Let's say you are using a popular hotel booking app in Taiwan to book a hotel in Taipei, right? And the platform can contain like hundreds or thousands of hotels, maybe hundreds in Taiwan. And of course, the platform owns certain hotels and have special partnerships with certain hotels. And this has nothing to do with subsidies, right? It's pure competition policy. Because the hotels, the platform may, when you search for a hotel in Taipei, the platform may, their own hotels can be boosted, while others get pushed down. So the platform shows you their preferred listing, no matter if those hotels are the best deals or have the better user rating. This kind of self-preferencing practice is closely related to both trade rules and the competition policy, and it can distort digital market and limit our choices, right? So I do believe it's about time to bring back the conversation. And this is where the trade negotiators and the competition authority can work together.
So this is one of those moments where Shin-Yi and I will start to disagree.
Good.
It's one of the first times, probably. So when you started talking about, I would start with a necessity test, I was like, no, that's way too legalistic for the question I think that Lockney asked. I would have started, too legalistic. I would have started with negotiations, because we lawyers are not relevant in that space, I think, where we get down to the nitty-gritty of the necessity test. That is 2005, when these rules really, really mattered. In today's world, I think we need to figure out, this starts to answer also, Cushing, your question. I wouldn't say regional trade agreements. I would say trade agreements amongst like-minded players, because I think that's the direction of travel. Whether that's then turns into like plurilateral agreements under the WTO umbrella or somewhere outside of it, don't know. But I think that's where the sort of, my opening remarks, I was trying to sort of push in that direction, but I can be much blunter. I don't think, for certain things, we as lawyers with nitty-gritty will still remain relevant. But the larger questions, I think, are about how do we govern these spaces amongst like-minded countries. And I think, for one, I'm going to put my German hat on and be very, very pessimistic about the future, that we see a multilateral way forward. We will have silos of rules in various ways, and it's going to become what the Germans call a Flickenteppich, and I don't even know how to translate that word, but basically means there's a patchwork of rules, essentially, that we will have to navigate, where lawyers will make a lot of money in the process. But in the creation of those rules, it'll be particularly complicated. Now, whether, coming back to innovation versus regulation, I think that's been the holy grail of trying to achieve that for a long time, but there have always been different answers to that. And sometimes, again, if you play out Europe versus the US, right? So slow Europe versus, and sometimes I'm like, no. Europe might be slower, but also might be more deliberate in protecting certain things. So it's always a trade-off, from my perspective, that you have. But let me come back to the sort of negotiations. You can have multilateralism, you can have regionalism, plurilateralism, unilateralism, whatever you want. I think what we're missing at the moment is simply a lack of common intentions. We have no identity around what the it is after this sort of kumbaya moment in the 1990s. And I think the end result will be for some players that they can move forward, and for far less powerful players to continue to be rule takers or not be included in the rulemaking process whatsoever, which is why I think the multilateral system was actually fairly useful. On competition, I have a much dimmer view even on that, because competition almost requires deeper integration with one another. And I don't think we see that. Therefore, I don't think we'll see it happening in the future. The one place where competition policy and competition rules on a non-state, on a non-country level works is the European Union. And that, I would argue, is almost akin to a country level type of competition enforcement policy. But I don't see it happening anywhere else, because you would need almost attribution of private conduct rules and so forth, and I don't see that happening, because you're then burrowing really deeply into regulatory autonomy of governments, and we're not at that space anymore. We're just not, at least not multilaterally. You might come to this point again. Gabrielle is getting ready to turn the button on and shut me off. You should have seen her. She like flicked the microphone across, and I was like, I'm getting ready to pounce. Tsing, just to come back to your point, I don't think anything of that should happen on a regional level any longer. I think we're past that point. It's, if anything, it might be a stepping stone, but if anything, it's going to most likely happen, and we're seeing the beginnings of that, on a like-minded country level approach. And in some sense, thank Trump for that, because you now see Canada and the European Union starting to talk much more closely with one another. You see other countries having more and more conversations, maybe at this point only, because they try to figure out what they want to do. The European Union starts to scale back some of its demands that it has traditionally made with respect to environmental or health issues and so forth. But I just don't see that happening on a multilateral level any longer, or at least not for the foreseeable future. Let me put it this way.
So that.
Unless Petros Mavroidis and Henrik Horn, who've written what many other people have said in other places, are correct that the US should withdraw from the WTO, which of course it will never do because it wants to continue to play spoiler. So let's face it, that's an unrealistic pipe dream.
So we have now only 15 minutes left, which means that we have a second round of questions and then we close the panel. So there is a question from Professor Marceau. If there are another, just let me see who else has a question, please. And is there any? And three. Okay, so we take these questions.
I agree with you that international competition may be too difficult, but there's a need for people in this room and for members of SIEL to think of a way to protect individuals from those new technologies and the multinationals. So whether it's national or regional, but something has to be done. And my other point was existing rules on subsidies need to be thought differently in order to cover new technologies.
Hello. Well, thank you so much for this very interesting panel. My question is quite general. I tend to agree with you, Markus, that lawyers are somehow misplaced, and yet they are very much needed. There are much greater questions than the international economic law question. When we talk about technologies, there are questions of freedom of speech, justice, human rights in general, democracy, obviously. So how is it that often international economic law specialists limit themselves to the technicalities of the Article 2, paragraph 26, when actually we're talking about not only the backsliding of democracies, but the end of the rule of law, the end of justice, and the end of freedom of speech?
We take that last question from the gentleman.
Yes, thank you so much. So I'm I think my inspiration derives from Gabrielle's question. So I'm trying to find some common grounds for establishing this multilateral regime. One possible proposal might be the law enforcement issue. So digital technology is actually a very useful weapons and instruments for criminals. So we see all these criminals, well, it's anonymous. With AI, you can use AI to spam or scam on a lot of things. And that has created real hurdles for most of the countries, including developed and developing countries. So I'm thinking one thing, is it possible to establish some kind of common grounds from this crime prevention perspective and trying to figure out some like common rules or guidelines for that? One instance could be the FATF, the Financial Action Task Force. It started from the money laundering, but it could be spreaded into the crime prevention. I think that could be a starting point. And that could lead to my second point question. So here, I think people thinking about liberalization of the digital industry to some extent. What about the opposite way? What if we borrow some experience from the international finance and have some prudential exception and basically allows countries to take whatever approaches to protect their legal justice, their society, while at the same time trying to establish some international guidelines to prevent some sort of abusive use of this prudential exception. That's how we establish rules for the international finance. We understand the importance of flow of money, but at the same time, we cherish the importance of financial stability and financial consumer protection. That's a common ground for us to reach the prudential exception without the necessity test at all. So is that a possible way out for the digital technology, the digital industry? Thank you.
Right, so we have 10 minutes to answer the set of questions. Please go ahead.
Just a very quick point about the fact that you've got these developments that are eroding democracy and human rights. I do think that there's a real concern there that, at least at the national level, a lot of states, developed states, that is, are not really embracing this idea of, regulation, and they are creating a false dichotomy between, regulation of AI technologies in particular and innovation, right? You've seen that this is also having an effect in developing states where the adoption of national AI strategies, there seems to be a race to the bottom in terms of these countries trying to open up their economies to attract investments and placing lesser emphasis on regulation. And so I do think that, given this, trend against regulation because of, concerns around its hampering innovation, we certainly do need to rethink how do you introduce some sort of multi-stakeholder governance that, prevents these very obvious harms that, the adoption of these technologies are already creating.
I just wanted to put a footnote to what Markus and Gabriel have said. Yes, I agree with it's all about trade-off. But I used to serve as a telecom regulator, but it's always a challenging task for a regulator to decide the timing of intervention. So the challenge is real about knowing when to act, when to regulate, right? If the government intervene too early, they may, disrupt very promising innovations. But if government waits too long, then it becomes hard and hard to address the problems like fairness, transparency. So it's all about timing, that it should be early enough to prevent the damages, but it should be late enough to have evidence-based regulation. That's a tough question. And also regarding Gabriel's comments, yes, since we are at SIEL, right? And this is the third days of the conference. We're approaching to the end, and we really, as a Taiwanese, culturally, I really like to wrap up something with positive and encouraging. Looking at the room, we should say something positive and encouraging. And so, in reality, that there's a gap between what's going on in the free trade agreements regarding the competition policy. Even the mega RTAs like CPTPP, all we see is quite broad statement, under which parties simply agree, yeah, we will promote competition, right? And without any substantial impact on competition policy. So there's a gap between what's going on in the free trade agreement and what's really needed for international cooperation on competition policy. And at the heart of this problem is that for the digital market, market concentration, market dominance is the key problem. It's the real problem because the winners get all. This is a winners get all economy that, for digital platforms, the more data they can collect, the more their algorithm can learn, right? And which will lead to more advertising revenues, and they can invest more in their data science, and then attract more users and collect more data, and the cycle just goes on and goes on and goes on. So that's why the competition policy is important. No matter subsidies or other issues, we need to link those rules with the competition policy.
So I'm trying to put a positive spin on my last notes. I found one, but in between I might go dark again. trying to link what Gabriel asked and what you said, I've never really understood why we always think of the government as an obstacle, because it can always be an enabler, right? So with respect to your timing comment, not every regulation is necessarily an obstacle to doing something. It's just sort of a framework, right? So if it comes down hard and there's lots of enforcement mechanisms, yes, but there could also be an enabler or a channeling function, right? So I think that's sort of what I have in mind when I think about this. Again, Gabriel, I don't disagree that we need competition. I just think that we won't see it on the multilateral level or on a large level. I think it's not regional, it's preferential. To me, you said regional, that's why I was like, I'm trying to sort of push back on the idea that we're always doing something on a regional basis. I think we will see countries that are like-minded coming together in various forms to do things. I think that's sort of a lesson that I think we need to be learning, and not to think necessarily in regional blocks as much as we have in the past. Again, that makes for a very uncomfortable, potentially very uncomfortable sort of patchwork of norms and patchwork of networks and so forth that makes things much more complicated down the line. Leila, I'm going to push back a little bit on you. I think IEL is part of a wider area, and I know you want to be, at least I assume most of the time, that you also say something a little bit more provocative. I think IEL is part of a wider framework of rules, and sometimes these are fragmented, but I at least tried to sort of say, let's open this up a little bit, and I think we need both. We need the wider thinking, and we need the nitty-gritty of legal work that has been done and has been done really, really well. Alex, I'm going to skip the law enforcement bit because and you've seen none of us have picked that up. I want to think about that much more carefully. But on the reshoring, I was actually thinking, and your sort of question of prudential exceptions. It sounded to me like this was sort of the reshoring debate. And then I thought your neighbor to your, I'm trying to figure out, your 7 o'clock, Greg, behind you, might have something to say about this, because that then runs into investment law issues. When you do that kind of reshoring, you might find yourself on expropriation issues, on FET issues. So these are sort of the questions that then might have other repercussions. I might get the question wrong, but I think that might well happen, unless there's, as Greg pointed out earlier today, there might be transition rules and so forth, but we then think about long-term sort of timeframes. Shin-Yi has prodded me to end on a positive note. The positive note is that you have another keynote event coming up with Gabriel and Peter and Thomas, and that might be much more positive. Sorry, Ujjal Bhatia. And the other positive note is that there'll be plenty of work for lawyers in this very fragmented world going forward.
So I would like to thank you, the three of you, but first I would like to just highlight some issues that you mentioned, and I think the question of innovation versus regulation, or whether the law adapts fast enough, is key. But also to just end up saying, as someone who works in the field of digital trade, this is not only about digital trade. Digital trade is not the solution for the problem of the adaptation of international economic law and technology. And I think here the point that you made about competition and these other rules, for instance, subsidies, and what we learn from financial regulation, it's really interesting. We should really not think only in terms of fragmentation geographically, but also not in terms of fragmentation about the body of rules that we have right now. So thank you very much. I hope you enjoyed the panel, and please run the